And welcome back to the Law and Crime Network. I'm your host, Amy Dash, joined by former prosecutor Bob Bianchi. Bob, we were talking before. You saw that there was a crime scene investigator on the stand, and you were saying that there are a couple of different ways to present that testimony.
Yeah.
What do you find is the most effective way, and how does it compare with what we just saw?
Yeah, it's a great question, Amy. Essentially, the prosecutor has to identify all of these photographs. This is the process that the law requires. They get marked for identification. A crime scene detective has to identify them and then say that they're a true and accurate depiction and how they got the photographs so that they're allowed to be introduced as evidence in a courtroom. That's the process.
Which can be a very tedious process.
That you took the word right out of my mouth. It's a tedious thing to do. You have to do it. So you try to find a way to make it entertaining or at least not have the jury completely go to sleep. So there's two schools of thought on how to do this. Old school thought used to be, as the witness is testifying about certain things, introduce each photograph one by one, have it marked for identification, have them authenticate, as they say, the photograph, that it's a real and accurate depiction, and then publish it, they would say, or show it to the jury at that point in time. The more modern way, which is the way that...
Well, let me just go back to that. So what does that process entail? It's just one or two questions where they're substantiating, yes, I recognize this, and this is from the actual crime scene, and then it's admitted right away, and they testify upon that.
Well, it's
object
into evidence. There's two different things. It's another really good question, and it's like
we're clarifying.
Yeah, we're going to Law School 101, right?
Right?
So you mark something for identification. It's authenticated by the witness.
Correct.
They can then testify about that piece of evidence. But ultimately, at the end of the case, typically, the prosecutor will ask for all of those things marked for identification to be moved into evidence, and then the defense attorney will have the right to object based on the evidence rules as to whether or not it can be allowed or not allowed. Now, crime scene photos are going to be admitted as evidence. There's no question about it, so long as they were properly taken and they accurately depict the scene. Now,
but your process that you just described, that's happening outside of the view of the jurors.
Well, it can happen inside. It is happening with the jurors there, the process of marking. So here's what a good lawyer does in my mind.
Okay.
Before the jury comes out, you have the court reporter tag and mark State Exhibit 1, 2, 3, 4, all your photographs. And then you want to get the witness in one shot, which is what's happening here, and say, is this a picture you took? Where was this picture taken? Is it an accurate portrayal? So on and so forth. Now, the jury may fall asleep a little bit about that. You got to try to find a way to keep their attention, but nevertheless, you want to have a mark for identification and, if possible, moved into evidence immediately. And what we try to do, Amy, is wedge this testimony, at least I tried to do, between primacy and recency are the most important things for a prosecution. Your first witnesses and your last set of witnesses tend to be the things in human nature that people will remember more. So we kind of throw the crime scene investigator in the middle of all that because it's really tedious testimony.
So some people may be scratching their heads and saying, if this is all going on in the presence of the jury sometimes, like you're saying, wouldn't it prejudice the jury because they're hearing about this evidence before it's actually admitted?
Yeah, well, the judge gives a charge. It's another great question. The judge gives a charge at the end of the day, and it says, ladies and gentlemen of the jury, only those things that I have allowed to be admitted into evidence may be considered by you. And he makes it very clear with respect to that. Now, if there was a super piece of evidence that could be very prejudicial and there's a dispute on the evidence rules as to whether it would go in, there would probably be a hearing outside the presence of the jury for your point. Judge, if you decide down the road that you're not going to admit this piece of evidence and the jury heard about it, it's unreasonable to expect that even if you give that charge to say only assess the evidence, that they're going to be able to forget about that evidence. So in those instances, there may be what they call a review outside the presence of the jury before it's actually admitted.
And I mean, this seems commonplace to you because this is what you did for a living, right? But to outsiders, it seems counterintuitive because it's like, how can you expect somebody to forget about something that they've already heard about?
Sure. And
it's human nature to consider something that you've heard, whether or not the judge tells you that that's acceptable.
Yeah, so the law is, you're right about that. The law says that a jury is presumed to follow the judge's instructions. But we all know that while that sounds very fancy and we would like it to be that way, that once something poisons that well, it's very difficult to get outside the minds of the jurors.
Right. So you were saying there's a second way to go about this.
Yeah, the second way is, as I indicated, is to basically mark all these things for identification ahead of time, have the witness testify to it, and then at that point in time ask the judge to move all of those photos into evidence because those are going to be the photographs that are going to be used throughout the trial. But your prosecutor's got to be careful. I've had cases where you've had thousands of pictures. Be judicious. Only use those those things that have the biggest impact as opposed to throwing everything out there, because you can overwhelm the jury's senses and kind of water out or dilute those things that are really impactful. So good prosecutors are very tailored and careful about what they're admitting as far as pictures.
And I'm sure it becomes easier in a case like this when you've got a second bite at the apple. You might know which evidence would be more persuasive to a jury, whereas on the first go around, you're sort of testing out the waters. You really know what's going to be influential.
I look at it a little differently. I think that as a general physics of law, of prosecution, that a prosecutor's case never gets better the second and third time you have to try it, because now really the defense knows the prosecution's moves and how they're going to go about things. And there's transcripts from the previous proceedings and witness testimony that the defense lawyer can now use to cross-examine the witnesses if they say something different. And typically speaking, human nature says somebody will say something 4 years ago and say something different 4 years later, and it gives the defense a lot of ammunition to go after them. Prosecution's case, you never want to retry a case, and so I think it actually puts the prosecution at a disadvantage. Because
you're saying that the time lapse creates inconsistencies with people because their memory may wane.
Well, yeah. First of all, you have, the more time goes by, the more difficult it is to get your witnesses in and to get them re-energized. People, after they've testified, kind of become more lackadaisical, but you also have a whole body of evidence through the transcripts of the previous proceedings that weren't in existence in the first trial, but are in existence now in the second trial, that the defense attorney uses to attack the credibility of the witnesses if their story changes.
What about something really interesting that I've heard about, which happened here in New York with the Eitan Pates case, when that person, Pedro Hernandez, was tried a second time and convicted. And what happened is, in between the two trials, both the prosecution and the defense spoke to the jurors from the first trial and got their take on what was effective. And you had a majority of those jurors wanting to convict. So therefore, they were very helpful to the prosecution. Whereas with the defense, there was only one holdout. And so when he gave his thoughts, I mean, it's like getting one person's thoughts versus 11 people's thoughts, right?
Yeah.
But they found that very helpful. Do you think that's something that should happen? And can that make it easier for a prosecutor to retry a case?
Well, when I first started this trying cases, you were not allowed to speak to jurors, period, full stop. It was an ethics violation. As time has developed, at least in New Jersey, and I'm pretty sure in New York would be similar, if the jurors are approaching you and you're not initiating the contact, you can speak to them. And of course, every lawyer that's trying a case wants to know, what were you thinking when you were in the jury room? What were the questions you had? Because, you know, we all know that a lot of times you may think that this piece of evidence is very significant, but when you speak to the jurors, you find out that collectively 12 people are going to be a lot smarter than you are, and they found something more relevant than what you thought was relevant. So on the second go around, you would, both the defense and the prosecution now have, if they get juror reaction, something that's very, very powerful in terms of how to redesign their case on the second go around.
It just seems inauthentic to me, though. It almost feels like a game where, like you said, you're redesigning your theory, right, based upon an insider's perspective. When it's really supposed to be objective, and you're supposed to use your strongest evidence. So if you're using your strongest evidence the first time, you should be using the same evidence the second time, right? You shouldn't be manipulating your case presentation based upon what jurors tell you that they were subjectively thinking when you presented your first case.
Yeah, well, I mean, listen, I mean,
it seems unfair to the defendant.
Oh, I don't think so. I mean, prosecution is not just about the evidence that you have. Of course, you want to make sure, and you're ethically responsible to make sure that you have probable cause and you believe the defendant is guilty beyond a reasonable doubt. But I've tried many complex homicide cases, death penalty cases, where, you know, there could be a question. Is it murder? Is it manslaughter? Is it passion provocation? Is it something less than murder? Or is it an outright not guilty? And your presentation is a very important part for any lawyer, a prosecutor or a defendant, in order to best advance their position. So I don't think there's anything wrong with getting feedback. I mean, before I try a case, I'll go anywhere and talk to anybody about the case, my friends, my family, people who are interested to throw out what I think the case, what's relevant to me. And sometimes somebody says, you know what's most relevant to me? And they bring up something and you're like, wow, I didn't even think of that. So I don't think there's anything wrong with tailoring your presentation so long as you're not changing the evidence.
Right. And when we were listening to this testimony from the crime scene investigator, she admitted that she didn't test a stain because she assumed that it was wine. And you and I like threw our hands up in the air. Like, what is this? Wine is red. It's the same color as blood. How would you not test it? And I brought up the point that there was a broken glass. There was wine all over the patio. There was a wine stain on Bob Ward's shirt, which he said he had no clue how it got there. it may indicate or at least make the inference of a struggle happening prior to the shooting more likely, excuse me. So what do you think about the fact that she wasn't testing things because she's making her own assumptions as to what it could be?
It's an epidemic. I talk about this in all sorts of media venues. The sloppiness, and I personally have been in charge of homicide crime scenes and been there and watched this. And I can remember one that I had where a priest had been stabbed a number of times, and they were calling it a suicide. But in any event, there was what we believed to be blood spatter against. Well, there was everywhere, but against the wall in particular, it was very important to us.
Spatter, not splatter, right?
Spatter, right.
Spatter, which is the pattern that the blood would make.
Right, which is very, good forensic people can talk to you about. Actually, it was underneath the kitchen table, so our argument was, as he was trying to get away, this wasn't a passion provocation, it was a committed killing, and he was actually stabbing him underneath the table, as you see the cast off and the spatter. But the problem was they never swabbed the substance so that we could prove that it was blood. Now,
and that's because they assumed it was a suicide, you were saying?
Well, no, but at first they thought they thought it was a suicide. Don't even get me into that. That happens all the time, right?
Yeah.
They're thinking it's a medical event, it's a suicide. But more importantly, when we said...
And you're referencing detectives or crime scene investigators that are getting to the scene and jumping to conclusions right away without testing any of the evidence.
Right. So with that case, when we finally determined that it was a murder, and then we realized that the crime scene people did not process that red substance against the wall, I remember having an argument as the person in charge, as the chief law enforcement officer of the county. I'm talking to a crime scene processing person saying, well, as far as what I'm going to say as a defense attorney, you did the best ketchup spatter analysis, known to mankind, because it's just sloppy. And a good defense lawyer, even though the jury may believe that this is wine in this particular case or blood in the case I just talked about, even though they may infer that based on the circumstances, the defense attorney is going to, if they're good, they're going to nick the prosecution with sloppy. And if you can't trust the work they did, then you can't trust the rest of the conclusions they came up with. It just makes the prosecution look bad. And as a lawyer sitting in a courtroom, as a prosecutor sitting in a courtroom, I don't need to have a case where a crime scene investigator didn't do the obvious, which is to submit it for analysis.
It's very interesting. I want to ask you a question about this plea deal. We hear that Bob Ward turned down a plea deal about a month ago. Can either party bring this up to the jury?
No.
Why is that?
Yeah, well, there are evidence rules, and again, there's another great question. So a lot of people just think it's kind of like...
I have to say, that one came from our producer, Kathy Rosen.
All right, Kathy, good job. Yeah.
Way to go, Kat.
So a lot of people don't realize that the evidence rule book, which is very thick, most states is about that big, is like a football game. You can move a ball forward, you have to, every 4 downs, get to 10 yards before you have another first down. There's rules in play. You just can't throw it all out there.
Great sports analogy.
Thanks. and before the prosecutor gets the ball over the goal line, you have to follow those evidentiary rules. And those evidence rules, even though people don't like them, are typically in place so that sloppy evidence isn't used to falsely convict a person. So in this particular case, there's evidence rules that say, in order to have a free exchange between a prosecutor and a defense lawyer, or any lawyer for that matter, even in a civil case, plea negotiations and settlement discussions are not admissible evidence. And the reason for that is it would chill or impact the free discussion between people to resolve a case. So therefore, it's not admissible. To be honest with you, here's the weird thing. People are kind of saying, how come the prosecution can't bring it out? Well, you can't because of the evidence rule. But there's a reverse to that. If the defense was allowed to do it, which they're not, but if they were, can you imagine being in front of the jury saying, ladies and gentlemen, the prosecution in this case, on this big murder case where they want you to put him in, to execute him or put him in jail for his life, offered him basically time served. But my client didn't take it.
Yeah, well, that's the crazy part.
And you know why he didn't take it? He didn't take it because he's an innocent man. That could be weaponized very well for the defense.
It does. It looks very bad for the state. But why do you think, I mean, this is mind-boggling to me. Why do you think he would turn down a plea deal and put him behind bars for 4 years with 6 years of time served when he was convicted the first go-around? And you have that very incriminating 911 tape where he says, I just shot my wife, I'm sorry.
I know.
How do you turn down something like that when he was facing 30 years on the first go?
It didn't make sense to me. Now, the only thing that I can think of that would make any kind of sense is two things. Either they are so confident that the 12 people are not going to convict them.
Based on what, Bob? Bob.
I don't know. I don't know. Or
from what we know, I wouldn't be this confident.
Yeah.
Would you?
No, I wouldn't be confident, and I would tell a client that as a defense lawyer now. I tell them, I said, listen, I mean, I could do a great job. I could make a lot of witnesses feel some pain, but in the end of the day, if the 12 jurors say guilty, you go to jail for the rest of your life. I go home and have a bowl of pasta. You gotta, you gotta spend your time eating bologna sandwiches.
What's your pasta of preference?
You know what? I'm a linguine and
linguine with clam sauce.
No, I make my own stuff.
Really?
Yeah, but I'm not a clam sauce guy.
Authentic.
Yeah.
Very nice.
I like shrimp in there, and a nice hot marinara sauce.
Very nice.
Thanks for asking.
Yeah, of course. We want to get to know you. All right. You know what? Let's toss right now to a clip of that 911 operator on the stand so we can hear the 911 call, and then Bob and I will come back and discuss it and whether or not it's incriminating.
What's your emergency?
I just shot my wife.
If this night.
You just what?
I just shot my wife.
Where's your wife?
She's right here on the floor. They sent somebody at 5277 Isleworth Country Club Drive.
5277 what drive?
Isleworth Country Club Drive.
Okay, I just need to giving me start coming up. 5277
Isleworth Country Club Drive.
Firework?
Yes, Isleworth. ISLEWRTH.
Okay, what's going on there?
I just shot my wife.
You just shot your wife?
I shot my wife. Yes, please. Send somebody over.
Stay on line with me. Let me add the fire department. Don't hang up.
I will.
Where's the weapon at, sir? Bianchi County Fire Rescue. The address of your emergency? 44.
5277 Isleworth Country Club Drive. Hello?
I'm here. Hold on just a moment.
Oh, I don't know why. I'm sorry.
That's all right. It's 12.
No, it's 52.
5.
Yeah, 77 Isleworth Country Club Drive.
I'm there.
I just shot my wife.
Okay, where's the weapon?
It's in the,
Yes.
I'm sorry.
Where is she breathing?
No, she's dead.
You know that for sure.
I think so, yes.
Okay, sir, where is the weapon?
It's in the nightstand next to the master bedroom. And I'll be glad to meet the officer that's on door.
Where is your wife, sir?
She's on the floor in the master bedroom.
How old is she?
She is 1954, whatever it is. More than 1954.
Okay, you're sure she's not breathing or?
She's dead. She's done. I'm sorry.
Okay. Sheriff's office, you're on the way? Yes, we are.
Thank you.
Okay, sir.
I'll be in the front door. It's fine. There's no weapon. I'm fine.
Okay, so we're on our way.
Thank you so much.
Sir, you need to stand up for me, but I just start to don't hang up.
I'm sorry, say again?
Sir, did you purposely do this?
No,
Or was it an accident?
it was an accident.
Stay on the phone with me. Do not hang up.
I won't. Thank you.
Yes, sir. I'm here. And the gun is secure, sir?
I'm sorry, say again?
You do have the gun secure, correct?
Yeah, it's next to that in the nightstand. The gun is secured, yes. It's not a problem when the officer would show up. I'll be sitting on the front steps.
How long ago did this happen, sir?
I'll be 5 minutes ago. From the front steps?
You're out on the front step?
Yeah, I'm on the front steps.
Okay.
And they come up front gate, from the front steps, and we go upstairs and find Diane.
How old is your wife?
1954, so let's see, whatever that is now. She's 55.
Is that the only weapon in the home, sir? Sir?
Yes, yes, I think it is. There may be one more like that's downstairs. I'm not certain.
Okay. What, the gun just went off, or what happened? What exactly happened?
The gun just went off.
Where was she shot at? Where's the wound?
I don't know where it is.
Okay.
This is awful. You see it on the floor, and I don't know how it happened.
Where is she at in the house?
Again?
Where is she at in the house?
She's in the master bedroom.
She is in the master bedroom also?
Yes. No, I'm downstairs.
No, she's in the master bedroom.
Yeah, she is.
Okay. Yeah, I'm here still. No problem, okay?
No, I'm fine. I think the fireman's now. I think it's first.
So what?
I think I was fireman here.
Okay.
Yeah, he's fine. I'm here at 20 and I think, yeah, they've gone past me. Yeah, they're attacking me. Come back up.
Did you see the deputy?
Yeah, I see lights, but then come back up. I can back up.
Okay. Can you step down and wave?
Well, I'll try to wave. Yeah, back up. No, wave.
Yeah, I'm here.
Hey, guys, over here. Over here. Yeah, right in the street.
Are you still on the front step?
No, I'm walking toward the street.
Where are you walking towards?
Toward the street because over here. Here, the other phone, I'll make that hot stuff.
Okay, sir?
I'm here, guys. No, I got a little phone. We're good.
Are you with the deputy? We can hang up. We're with you.
Oh, okay. Okay.
No further questions, Your Honor.
And welcome back to the Law and Crime Network. I'm your host, Amy Dash. You were just listening to the 911 call that Bob Ward made right after shooting his wife. You could hear on the tape he said, "I just shot my wife several times." And when asked whether she was breathing, he said, "No, she's done. She's dead." I'm here with former prosecutor Bob Bianchi. Bob, how damaging is that 911 call to his case?
You know, so we look at a piece of evidence and we say to ourselves, it doesn't make a difference what Bob Bianchi thinks about it. What impact is this having upon a jury? And I'm hearing this now for the first time myself as you're playing it to your viewers. And I'm like, yikes, man, this guy is just like way too calm for such a tragic thing. And this will play into the prosecution's theme that calmness and his deliberation and calling and is because it was something that he had set out to do, or he knows that he did something wrong. But even people that commit
the defense
murders,
play it the other way, Bob, and say he was just totally shell-shocked?
Yeah, I mean, you want to say he's shocked, and none of us, and he's been drinking, and none of you know how you would react, and the shock is what caused the calm demeanor. But nevertheless, jurors tend to not operate on psychological theories, but basically put themselves in the place of a person and says, "Wow, if I were accidentally shot my wife, I think I'd be a tad more excited than she's done."
Right, well, of course, but it's very hard by the same token to ask people to try to relate to somebody who just killed someone. Because most of the jurors, I would think all of the jurors on that, in that area are not killers. right? So how can you even relate to somebody who just killed someone?
Well, I use common sense. I mean, all trial work comes down to the rule of common sense. And of course, you have not witnessed a murder yourself or participated in a murder, but you would expect that if it was an accident, think about any accident. If your wife got into a car accident, take the common things that have occurred in your own life and use your common sense. You've reacted to your child, getting knocked off a bicycle with greater reaction than a guy who accidentally shot and killed his wife.
Does it matter that she was dead and there was no way to revive her? Meaning if somebody called and the person was still alive and there was a chance to save them, maybe they would be more hysterical about 911 getting there right away.
Yeah, look.
Versus him knowing that there's finality.
Yeah, as a prosecutor, I'm not sitting there in chapter and verse going through every little permutation and nuance about if she were dead, would have you reacted different or not. What I'm doing is using a common sense argument that this is not the sound of a person who a tragic accident occurred, your wife just got shot, blood all over the place, she's dead, and this is not the way a normal person would typically react. But I wouldn't make my whole case about it. I would be using other evidence to bring that piece in. So what
about how the 911 operator handled the call? I mean, she really didn't probe for that much information, and then when she said, did you do this on purpose? And he said no. She almost led him with the next question and said, well, was it an accident? Oh, yeah, it was an accident.
Yeah, no, I did.
It's like she fed him the answer.
Yeah, the 911 operator did what 911 operators do.
Shouldn't they be trained better, though? Because those calls are so critical. When they're admitted into evidence later on at the trial, they're so critical because it's right after it happened, and you can really get to what was in the person's mind and how did everything unfold.
Sure, and some people do better than other people, but they're not being trained as crime scene people, not being trained as detectives. They're being trained to get data. Would have I preferred the person to say, tell me how it happened and get an explanation? Sure, but you got to remember too, when a dispatcher is doing, when you're listening to that tape, the dispatcher is doing a number of other things like dispatching emergency services and also talking other lines. A very high pressure job.
Right.
In the case that we were talking about, interestingly enough, with the priest who was killed and the best ketchup spatter analysis case, there was a 911 aspect to that call too, and the 911 operator got a lot of heat because the priest called 911 and the bad guy hung the phone up. And 911 reverse dialed the phone, and the bad guy picked up the phone and said, she said, is there a problem? Is there an emergency? He said, no, everything's okay. And faintly in the background, you can hear the priest say, no, it's not, help. Now, we knew that was the first round of stab wounds that he had, and then he sustained more stab wounds down the line. But the 911 operator got a lot of heat
because they didn't respond?
Because they didn't dispatch police, and Bobby wasn't found until the next day. Listen,
unbelievable.
I mean, everybody tries to do the best they can.
Yeah, of course. And so what about when Bob Ward says, she's done, I'm sorry? First of all, did his apology sound remorseful to you? Did it sound authentic?
No, it just sounds odd. It just
the whole
does
thing's
not
odd,
sound
right?
consistent with a person who is witnessing an accident happen, as opposed to very calm. She's done. I'm sorry. Can you get the guys over here? To me, that as a prosecutor, I'm going to be arguing that is because he knew he did something wrong. It wasn't something that was unanticipated, and he's basically like, "Look, she's done. That's what I intended to do. Come on over and let's rock and roll." As opposed to somebody like, "Oh my God, my wife has just been shot. It was an accident." It's in the law, Amy, as well as I do. Excited utterances is it's an exception to the hearsay rule, right? Where if somebody's blurting out something in an excited state, it could be admissible even if it's introduced in court as hearsay. And the part of that rule is that you expect people are going to be excited in certain circumstances. And certainly to me, as a prosecutor, I would be bringing out, this is one of those things, folks. With all due, I'm being like you're the juror there. With all due respect, folks,
I'll put my
this is
hat
one
on.
of these things. I've never been there. I've never shot my wife. My wife's never been killed, nor has anybody probably on this jury. But you would expect that after you accidentally shot your wife and she's dead, you'd have a little bit more emotion.
An ounce of emotion.
On this thing. Yeah. And then move on.
Yeah, absolutely. What about the fact that he was so willing to turn himself in? And it seemed like he wanted police to get there right away. He said, I'm glad, I'm happy to meet them out on the porch. He was going to give them the weapon. Does that show that maybe this was an accident? Or could it also support the fact that maybe he did this intentionally and he felt like he wanted to take responsibility at that moment? Fast forward a couple years and he's on trial and he's like, wait a second, I don't want to spend 30 years in prison. Maybe I shouldn't have turned myself in so quickly.
That's why I should have taken a plea deal.
Yeah.
But yeah, I mean, I think that the evidence in balance the 911 call weighs more favorably to the prosecution. But be assured, the prosecution needs a heck of a lot more than just a person's reaction on a 911 call in order to prove a case beyond a reasonable doubt to 12 people.
Yeah. What about the fact that the first conviction was overturned on the basis that the original defense attorney, who was dead at the time that he was saying that he had ineffective assistance of counsel and trying to get it overturned. So the defense attorney couldn't even defend against that claim of ineffective assistance of counsel. But it was overturned because he had originally not objected to, there were a lot of references made to this guy's not answering certain questions. Mm-hmm. And the judge said, well, he has the right to remain silent, so you can't use that information to try to convict him by saying that he's guilty just because he wouldn't respond to certain questions about his wife. Or, for example, he's being interrogated by the police, and he brings up his daughter and he brings up sports, but he doesn't talk about his wife. You can't use that to try to incriminate him and show that he doesn't care about his wife because he has a right to remain silent.
Right. So if
the judge agreed with that.
Right, and that's a great body. There's a lot of texture to this question, but you have a right to remain silent, and the Supreme Court of our country has said that that right is to protect both the innocent as well as the guilty.
Right.
And
so you're not allowed to bring it up then, right?
Every prosecutor knows rule number one, or you should know. Unfortunately, there's a lot of sloppy prosecutions going on. But you cannot comment on a defendant's exercising the right to remain silent. You can't infer anything from it. You can't whisper about it. You can do nothing that implicates the right to remain silent, because a good prosecutor doesn't want to just win a case. They want to win a case that is ironclad, so that it can go through the appellate process and not have to come back like we have here.
Sure.
When I was the boss, I had 33 assistant prosecutors under my control in the county that I was the head prosecutor. If any one of my people went and now, can you do it inadvertently? Yeah. I mean, it can happen accidentally. Where does it normally happen, Amy? When lawyers are charged up, prosecutors in particular, in summations. There is so much prosecutorial misconduct.
They slip,
that
you're saying.
They slip.
Yeah.
And you got to really be disciplined about it, because you don't want to put witnesses and the families and everybody through a second trial because you make a bonehead mistake and inadvertently comment on the defendant's right to remain silent. And it happens a lot.
Now, what if you slip? Can't you can take it back? You can withdraw it, right?
Well, with the essentially, and I don't know what happened in this particular case, but the defense.
Well, they referenced it 25 times.
Yeah,
apparently.
well, that's a problem, and well, of course.
So you agree with the judge overturning the conviction?
I didn't listen to the exact comments, but if in fact a court found that they improperly invaded the Fifth Amendment right to remain silent, then yes, I agree. And certainly one time is bad enough, 25 times is horrible. What typically happens when a piece of evidence comes out in a scenario like that, you would hope that the defense lawyer and or the judge, right, the prosecutor shouldn't do it, but the defense lawyer and or the judge would give what they call a curative instruction to the jury. They would stop immediately. It's got to be done timely, and it's got to be forceful. And they basically say, ladies and gentlemen of the jury, that comment was just made by the prosecutor. You are to disregard that comment. Absolutely do not consider that comment at all in your deliberations. Do you all understand? Does anybody have a problem doing that? But even if a judge does it, and he does it timely, when you're talking about invading the Fifth Amendment right to remain silent, the prosecutor just put the case in significant peril of reversal.
Yeah, and so you're saying that the judge has the option to just intervene and tell the jury not to consider.
Absolutely.
Right? So this is the same judge that overturned the conviction, was the same judge that presided at the original trial.
Right.
So she heard it 25 times. So is she just covering her behind here, or like what's going on? Because it seems like she is part of the problem because she never made that instruction to the jury despite them bringing it up 25 times. Why did she drop the ball?
Yeah, I can't account for it. I mean, I have seen a diminution in the quality of judges. A lot of times you're appearing before judges who have never handled criminal cases. Some judges are very good, but they were civil attorneys and not criminal attorneys, so they don't really have that feel for it.
Yeah.
But, there's nothing unusual with the case being retried by the same judge. In fact, it kind of makes sense because they have a knowledge of the case or whatever. If they make a mistake, a lot of times judges make a mistake with the jury charge at the end of the case where they instruct the jurors on the law. So it's not uncommon that if an appellate court reverses it because there was error in the trial, that they would give it back to the same trial judge because they have all the law and all the information, and hopefully they'll do it again without the error.
Yeah, but this judge overturns it, and I'm wondering if it seems like that was her only option, because if she doesn't overturn it, right, then it's going to go to a court that's higher than her. And they're going to basically reprimand her for missing the 25 references and not jumping in once. It's going to be embarrassing to her, so she had to overturn.
Yeah. I mean, it's extraordinary that 25. I mean, I've seen cases get reversed based on some really, the prosecutor says something and says, well, you didn't, hear anyone tell you anything different. That can be a basis in which cases have gotten reversed, even though they didn't directly refer to the defendant themselves not speaking, but they could. The argument is the jury could have inferred it. To have it happen 25 times is quite extraordinary to me.
Absolutely. So let's toss now to listen to Brian Cross from the Orange County Sheriff's Office. He was one of the lead detectives, and listen to his testimony from earlier in this retrial.
All right, good morning.
Good morning.
All right, can you please introduce yourself to the jury?
Brian Cross.
All right, can you spell your first and last name for the court reporter?
BRIANCROSS.
All right, now, Mr. Cross, where are you employed?
With the Orange County Sheriff's Office.
And how long have you been employed with the Orange County Sheriff's Office?
About 19 and a half years.
All right. Can we hear you a little better now, I think?
Hopefully.
Okay. Now, back in 2009, what unit in particular were you assigned to with the Orange County Sheriff's Office?
I was assigned to the homicide unit.
And in the homicide unit, were you the lead detective in this case?
Yes, I was.
And do you work alone, or do you have other members of the Orange County Sheriff's Office assist you in your case?
We work in generally teams of 4.
Now, at a certain point during the early investigation, did you have the opportunity to meet James Ward?
Yes, I did.
All right, and do you see him here in the courtroom today?
Yes, I do.
All right, you please describe him.
It was a gentleman that was just standing up with glasses and a blue jacket, red tie.
Thank you. And let the record reflect that the witnesses identified the defendant. Now, while you were meeting Mr. Ward, did you provide him with his BlackBerry cell phone?
Yes, I did.
Now, I'm going to approach what's already been entered into evidence of States 13. Can you take a look at States 13? You can open it up. Do you recognize States 13?
Yes.
And is this Mr. Ward's cell phone, the BlackBerry that you provided to him?
Yes.
Now, as part of your investigation, did you travel to the medical examiner's office in Miami-Dade County?
Yes, I did.
All right, can you tell the jury why you went to the medical examiner's office in Miami-Dade?
I went to the medical examiner's office to bring the forensic photographer the firearm that was used in this case. And there was going to be high-resolution, high-speed photographs taken of the weapon as it was being fired.
Now, that sort of testing and that sort of lab work, is that available up here to the Orange County Sheriff's Office?
No, it's not.
Now, I'm going to show you what's been marked for identification as States Exhibit P.
You can go ahead and open it up.
Do you recognize States P?
Yes, I do.
Can you tell the jury how you recognize States P?
That was the firearm that was collected from the scene and that I brought to the photographer in Miami.
And that revolver took a field trip with you to Miami?
Yes.
All right, is that the .357 revolver?
Yes.
One moment. All right, now I'm going to approach what's been marked for identification as States Exhibit AB. Do you recognize the contents of this envelope?
Yes, I do.
All right, can you tell the jury how you recognize the contents of State's AD?
It's an office envelope that I put the ammunition, the test ammunition, down to take down to Miami.
All right, now when you say test ammunition, what do you mean by that?
It's just ammunition that's not was not related to the crime or the scene in any way.
All right, so essentially store-bought .357 ammo?
Yes.
Now, when you arrived down at the Miami Medical Examiner's office, what items did you turn over to the medical examiner's office?
The firearm and the ammunition.
Good morning.
Good morning.
As to these photographs that have been not introduced but identified by you, you didn't take the photographs, did you?
No, I did not.
Were you present when they were taken?
Yes.
They were taken by somebody else, correct?
Correct.
They were actually enhanced, weren't they? In other words, the photographs that you identified have been enhanced, have they not? The resolution has been enhanced.
I believe so, yes.
So they really don't, when you said show, truly and accurately depict what is shown therein, the photos really don't show the actual picture of what was taken down there, do they?
The photographs show the projectiles exiting the firearm that's...
After the photographs have been enhanced by either you or by the photographer, correct?
Yeah, correct.
And also, they're not the same size, are they? They've been downsized, correct?
I received large prints. That's what I viewed.
And they have been downsized, correct?
Yes.
Okay, so we have the photographs that you said were true and accurate depictions, and now we know that they have been downsized and that they do not accurately depict the resolution or the brightness of the actual photograph when it was taken, correct?
The photographs appear to be enhanced from what I saw.
But what you saw was the photograph. These things take photographs of something in a millisecond, don't they?
Yes.
So you can't tell us the photograph that you saw is actually what your eye saw, correct?
Correct.
So when you say you saw it, what you really mean is you saw the picture after the photograph had been taken, after it had been enhanced and downsized, right?
Yes.
Okay. Now, earlier you indicated that you were the lead detective, correct?
Yes.
And as a lead detective, would you make decisions about what would be tested and not tested?
Yes, I would confer with the crime scene investigators. Yes.
And who did you confer with?
Regarding what?
Confer with what would be tested or not tested. Did you confer with Ms. Vibert?
Yes, but could you be more specific on what test?
Oh, I will. Was it your decision or her decision not to do a DNA testing on the holster in the master bedroom?
I don't recall discussing the DNA for the holster.
Were you there when Ms. Vibert was conducting DNA swabbings of various elements there?
No, I was not.
You were not there?
No.
Did you arrive later than that?
At the residence?
Yes.
Yes, I did.
So were you there when Mrs. Ward's body was still there?
Yes.
And was there a discussion about doing any GSR testing on her hands prior to leaving the scene?
No, not at that time.
Okay. So you had no discussions with anybody, anyone from the medical examiner's office or anyone else about doing a GSR testing, gunshot residue testing on her hands at the scene, correct?
You would not do that at the scene. We do not touch the bodies at the scene.
Well, but in conjunction with the medical examiner, you could do that, could you not?
At a later date.
Pardon me?
Possibly at a later date.
So in conjunction with the medical examiner's office, now she had been there in the room for some time, correct?
Yes.
So this was not a situation in which you would need, it wasn't an outdoor environment where you had to worry about the deceased having rain or some sort of outdoor element affecting the scene, correct?
Correct.
It was a controlled environment in the bedroom, correct?
Yes.
And so the necessity for kind of moving her expeditiously really, there wasn't any need for an expeditious movement based on the environment in the room, correct?
Right.
And so one could have, as the lead detective, asked for an opinion about conducting some sort of gunshot residue on Mrs. Ward's hands if you chose to, correct?
That is not what I would normally do, is request a gunshot residue at a scene.
Well, you didn't do that, did you?
No, we wouldn't do that. We do not touch the bodies at the scene.
Well, now, well, tell us about what you did later to do any gunshot residue on her clothing.
I did not, no.
Did you, as a lead detective, ask anybody, would you please run some gunshot residue on the clothing of Mrs. Ward? Did you do that?
No.
Do you know whether anybody else did that?
I don't recall.
Okay. Now, in terms of the DNA sampling, as a lead detective, did you say, all right, we need to do some DNA sampling here on other items other than the gun, like the holster? Did you discuss that with anyone?
Well, there were numerous items I've collected, and we would discuss what items would be submitted for DNA.
Pardon me?
There were numerous items collected from the residents, and then at a later time, there would be discussions on what would be submitted for DNA testing.
Okay. Well, some items were tested out there in the scene, correct?
That's possible. I do not remember that. I may not have been there.
Well, are you lead detective? Are you aware whether there was any DNA testing of the gun by Mrs. Vibert at the scene that evening or in the early morning hours of September the 22nd?
I'm not aware of any DNA testing at the scene.
And welcome back to the Law&Crime Network. I'm your host, Amy Dash, here with former prosecutor Bob Bianchi. Bob, why don't you switch hats for a second? Let's say you were the defense attorney in this case. What would your argument be, aside from the whole this was an accident, right? How would you bolster that claim, besides just stating it? How are you supporting it?
Okay, well, as a defense lawyer, this is just standard defense lawyer stuff. You go up there and you indicate that, look, we don't have to prove anything here. That responsibility is on the state to prove beyond a reasonable doubt to all 12 of you, and they can't do it. And here's why. Sloppy investigation. I mean, you want to know sloppy? How about this? They don't even test what they claim is wine and send it to the DNA. Come on, folks. You can have the common sense to know that basic investigator school 101 would tell you to do that. And if that's a problem, you can expect that all the things that they are doing are sloppy, just like their assessment all of a sudden that, this is a murder as opposed to an accident. They got to prove that to you beyond a reasonable doubt, and they can't do it. That's the essence you want to go through. And of course, as in an opening statement, a defense attorney wants to be very careful. They don't have to even give an opening statement. You don't want to commit to anything in it. You want to talk about the general principles that I just brought out there. And then you want to nick the witnesses all the way along when you know for sure that they've done something, just like we're seeing here with the crime scene investigator. That is a basic thing. And when they're given different theories, the state comes up with something that's a different kind of theory. You want to argue, well, which is it? Is it this or is it that?
Right.
But the defense attorney kind of has to lay back a little bit and wait for those opportunities to come.
It was funny that you said you just want to sort of stick to general principles, because when you're giving me that argument, I'm thinking, well, that sounds kind of shallow.
Yeah, no, well,
there's really nothing substantial about it. It's just undermining the presentation of the prosecution, basically.
Yeah, you're going to hear things, ladies and gentlemen of this jury, that you are not going to believe. Trust me when this comes out, because there's been all sorts of discovery and files and reports, and we all have them in our possession. And they come in here with this case, and you're going to see such sloppy investigative. But you don't want to go too far. But you just wait, because like the judge told you, it's not until you've heard all of the evidence, every piece of evidence, and after summations, that you should even be considering whether a person is guilty or not guilty of anything. And we believe in you, and we believe you'll follow your oath, and you'll do that, because the defense has got a lot to say about this crappy case, however you want to put it. But the defense attorney's got to be careful not to commit, or even as a prosecutor, when you get up there in your opening statement and you make a representation. One of the reasons I think that I was very effective as a prosecutor is I'm not a particularly smart guy. I'm not like a genius. I was always average on every test, if not below average, and probably half mentally ill. But nevertheless, I was believable.
You build yourself up and then you tear yourself down in the same sentence.
No, but see, it's important that a jury doesn't think that you're a regular person and that you're speaking to them in common sense terms.
Right.
And everything that you say that comes out of your mouth, you have to deliver. And if you don't, when I always say, in my opening statements, I always say, as a defense attorney or a prosecutor, I'm going to say, I know the judge is going to tell you that anything a lawyer says in opening and summation is not evidence, but I want you to hold me accountable. And at the end of this case, I'm going to go over what I went over in my opening statement. And trust me when I tell you, there won't be one thing I'm saying to you right now that is not proven by the evidence in this case. But you better make sure that you can deliver.
Okay, then how do you overcome the medical examiner's testimony that says that this was a shooting that occurred 18 inches away from the victim? Obviously, that undermines Bob Ward's story that, well, he had several stories, and you could say they were consistent or inconsistent. It could really go either way. But first he said, well, my wife was trying to commit suicide. I wrestled the gun out of her hands and then accidentally shot her. So you would assume that's at close range, right? But the medical examiner says, no, 18 inches away. Second story. All of a sudden I come into the room and I turn around, my wife's behind me pointing a gun at me. So, okay, but then if you have to go over there, wrestle the gun away yet again, are you backtracking 18 inches away and then shooting? I mean, how does it become an accident? And how do you overcome that? And also, if he's taking the time to move 18 inches away, does that indicate any type of premeditation?
Well, listen, the strongest pieces of evidence that I know about this case right now, and of course we only know pieces of it, we don't know the whole thing based on what's being reported, is as a prosecutor, they're going to try to tie in the conflicting statements with the forensic evidence from the pathologist. And as a prosecutor, I want to be saying in summation, so we're always thinking about in our minds, what is it that we want to say in summation? And then we build our case, we go backwards and we build our case that way. So what I want to be saying in summation is that the medical examiner who testified there's no soot, there's no powder burns, there's no stippling, as they call it, which is a close range shot that wasn't existent, is independent, objective proof that doesn't rely on perception, it doesn't rely on making mistakes. It is what it is. And what it shows is that this was a distance greater than what he is telling you, which is consistent with murder as opposed to an accident. Plus the lack of injury to himself in terms of powder burns or stippling if he's wrestling with a gun, things of that nature. Now, I'm certain that in addition to the pathologist, they're probably going to call a ballistics person who's going to come in and explain the mechanism of how a weapon fires so that the jury can hear how the I don't know if it's a revolver or probably an automatic, how the casings eject, the powder burns that would exist, what would happen if you were holding the gun, the distance upon which there is before there'd be a powder burn or stippling either on the body or burn clothing. That's why the pathologist is saying it has to be 18 inches or more away, I would imagine, is the testimony. There's no pathologist that can sit there and say it's 18 or 16.
Well, that's what I was going to ask you. I mean, I know you're not a medical examiner or a pathologist, but how reliable is that assessment? How can they know it's exactly 18 inches away?
Yeah,
it just seems so speculative.
My experience,
I would counteract that, by the way, if I were a defense attorney, with a different expert saying the total opposite.
Right, and we don't know if they have an expert. And look, it is true that, look, I put many witnesses on a witness stand, pathologists in particular, that talked about the distance of a weapon being fired, because it's a generally accepted fact that between 18 inches or more, you would expect to see some residue of the weapon stippling, which is the powder burns going on the clothing. But it is not an exact science, and so you were right. A good defense attorney is going to, and I don't know if they have it here, is going to have an expert to say that's junk science. I mean, there are multiple circumstances under which a gun may not show stippling or powder burns, and while that may be a generally accepted rule, it doesn't necessarily mean it is an absolute scientific fact, and that's what the defense wants to try to hit that piece of evidence with.
What about Bob Ward asking to wait a little while before being tested for gunpowder residue? Should that fact be admissible, just hypothetically speaking, and could it hurt him?
So long as it wasn't during the piece where he was exercising his right to remain silent, so let's assume that the judge says no, that is not a violation of the Fifth Amendment. The question becomes, and it's a very good question, do we want to admit as prosecutors the evidence that he did not want to do the GSR, the gunshot residue, testing? I would be admitting that and arguing that it's consciousness of guilt. Anybody who is trying to show that they're innocent and that they didn't do anything nefarious cooperates fully. Why would it be, of all things, he decides not to allow examiners, after he gives this story, to test the gunshot residue? I'll tell you why, ladies and gentlemen, jury, because he knows it's going to show powder on his hands that's inconsistent with what he told whichever story you want to try to accept, version 1, version 2. It's like a Chinese menu of options he gives you as far as what happened. That's inconsistent with guilt. The fact that he wouldn't be tested, that's inconsistent with an innocent person, I should say.
If you are the defense attorney or even the prosecutor, I mean, try to play both sides here. How are you making a distinction between a crime that happens in the heat of the moment versus an accident?
That's another great question.
Can it really be the same thing, and therefore there should be culpability even if you're going to call it an accident?
Well, okay, that's a huge thing where the defense may go here, right? So you can give alternative theories to an incident. We have a broken glass, we have wine, we have these financial pressures. We're really not sure of everything that was going on yet from the testimony, but just because you may have killed the person doesn't necessarily mean it's a murder. There's something in between not guilty and murder, and that can be manslaughter or passion provocation, as they call it. In other words, it's not that he didn't do it, it's not that he didn't intend to do it, but if you can prove that he was under the reasonably excited state, and that it was a reasonable provocation, and that a reasonable objective person could have acted that way, and they didn't have an opportunity to cool off, it changes the conduct from a purposeful and knowing murder down to a manslaughter, which is a significant reduction in sentence. And Amy, you may have hit the reason why they didn't take the plea deal here. They may be thinking that there's no way the government can prove beyond a reasonable doubt murder, which means he'll spend the rest of his life or death. They may think that at worst, he only can get convicted of a manslaughter or passion provocation, and with all the jail time he has in there, he'd virtually be parole eligible anyway. So why not roll the dice? I'm kind of thinking now, as we're working this out, that could be the logic why they wouldn't take a time-served plea offer.
So do you think then it hurts them to keep going with the semantic of an accident and trying to claim that he shouldn't be responsible at all, versus just saying, listen, this was manslaughter? Yeah,
so we don't know yet. Do I think that the defense has a lot to argue here because we don't have any direct evidence of it being murder? It's a circumstantial case for the prosecution. You got to make sure all your circumstantial pieces are put together well and you connect them and tie them up. And remember, the defense is armed now with transcripts from previous witnesses that have testified, and they're going to be able to put a lot of dings in the case. But there's nothing that prevents the lawyer down the road. In fact, sometimes the judges are required, even if the defense lawyer doesn't want them to charge the middle ground charges. They're called lesser included offenses, because the Supreme Court has basically said you can't leave a jury with an option as draconian as not guilty or guilty of the highest charge. If the evidence warrants it, the judge, even against the objections of the attorneys, has to give the middle ground charges, a lesser included offense.
And even if they don't originally, if the prosecution doesn't charge with the lesser included charges, a jury in some instances can still find somebody guilty on lesser included charges, whether they've been charged or not.
Only if the judge charges them.
Yeah, once the judge, but that can happen in the trial. What I'm saying is that they don't have to initially charge them at the outset with the lesser included charge.
Absolutely. Like I've signed many indictments in my career. So the indictment reads knowing and purposeful murder. But during the course of the trial, the defense argues passion provocation. And the only standard, it's very low, is the judge says, is there any possibility that a single reasonable juror could find it's passion provocation or manslaughter, and if so, they have to charge it. And prosecutors, again, have to be smart. And I've seen, again, we're going back to the same thing about not commenting on the right to remain silent. If the jury charge should be charged, prosecutors should allow it to be charged so that it doesn't get reversed down the road. It's not just about winning the case, and I would always tell my staff this: I want you to put the ball over the goal line, and I never want it to be back on the field again from a reversal in the appellate division.
Okay, let's hash this out even more for the viewers, okay? I really want them to understand it 100% clearly. So let's take Bob Ward's story as true, that in fact there was a little bit of a struggle with his wife because she was trying to kill herself. He tried to remove the gun from her hands and it accidentally went off. Would that be heat of passion killing, or is that purely an accident?
That's purely an accident.
And so there's no liability for that?
And if it is an accident, if it
Zero
was, well,
liability.
it could be reckless conduct. It could be potentially a manslaughter, which is reckless conduct. But
Right.
if you're talking about a struggle over a gun that somebody else introduced, the victim introduced,
Yeah.
I can't see a conviction in that case. And let's go back to something that you said before, which is one of the things that a good investigator will know, and if a good defense attorney is smart enough, he's going to say, sir, have you ever been, or madam, have you ever been investigating a case where a person is not guilty of something, but they lie anyway? They lie anyway because they think it sounds good. I mean, you're pretty much, if you know how to do it, are going to get an investigator to say, yes, that happens. So you don't know from the version he told you, so whether it's a struggle or whether or not it's the other one. He could be lying because he's trying to make it look better for himself, but in fact didn't really commit a murder. That's possible, right? Now, how are you going to get a witness not to say that's possible? And that's reasonable doubt.
Right.
If I get one of those guys to say it's possible, then I'm coming at the end of the trial as a defense lawyer and I'm saying, look, you may not like the fact he gave varying versions. Maybe it was because he was scared, nervous, upset. Maybe he was trying to cover. Who knows? Maybe people lie, unfortunately, when they're stressed under these circumstances.
Correct.
But the state has not proven to you concretely that this was a purposeful and willing and knowing murder. I mean, are you comfortable, ladies and gentlemen, executing somebody based upon all of these conflicts? And even a detective who tells you that it is not uncommon for people to lie, even though that they had not committed a murder, that'd be damning. But the lawyer's got to be careful and pick their spots, the defense lawyer, as to making sure they can get that out of a witness. I'm pretty confident as a defense lawyer, when I've asked questions like that, I get them to answer it because I lead them down a path where it's almost impossible for them to pass the straight face test in front of a jury and say, no, people that are innocent don't lie. People lie all the time.
Oh, well, I mean, it seems like there's a lot of room for reasonable doubt, but what you're saying is it really comes down to the lawyering skills of whoever's representing the defendant to show that, hey, really the only piece of evidence here that would indicate that it wasn't an accident is the medical examiner saying that it was 18 inches away. So it seems that if you have an expert to counteract that testimony, what are you left with besides people wondering what went on in that house?
Right, and
we don't know.
That's a great question. So, like, I'm saying, if you are wondering, ladies and gentlemen, about what happened, then what you're doing is yelling and screaming, there's reasonable doubt in the case.
Right, but you have to bring that to their
wondering.
awareness, right,
Sure,
Bob? And
sure.
so that's key, is it's really up to the lawyer to do that.
Well, listen, I mean, as a prosecutor, I will say this. There were many times that people wanted to know what went on in that special room when we were ultimately making decisions. It wasn't really brain surgery. So what would go in is one of my assistant prosecutors would come to me and they'd say, look, we got a little trouble with this case. There's some evidentiary issues. We believe the person did it. So we would ask, okay, what are the issues? Say, for example, they didn't take the spatter analysis. They didn't do this, that, the other thing. And we would take it into consideration and we would be doing a cost-benefit analysis. Can we win the case or not? And ultimately, Amy, the most crucial question became, who's the defense attorney in the case?
Sure.
And one of the reasons we asked that is this is not an improper thing. We believe the person is guilty, let's say, for example, of murder. We just know that there are some things that happen that make, that in the hands of a very skilled defense attorney, make our likelihood of securing a conviction much less. And then there's some attorneys who...
Unless you have a rock-solid case.
Right. So usually it doesn't come to the head guy unless there's some issue that comes up, like, boss,
Right.
we got a problem with this.
Yeah.
But, you know, you look at it, and there was one in particular where I was like, well, we're going to go forward with the case, but this is one kick-butt lawyer who really knows what he's doing. And I made my
He knows how to
detectives-
exploit your holes.
He knows how to take it and like with a violin, boy, he plays it and he turns it into an orchestra, and you know you're going to feel pain as a prosecutor. And what I did in that particular case is I made all of those detectives that made the mistake sit in the courtroom in summation to listen to him, and I can hear it to this day as he was yelling, "Shame on you for not," and "Shame on you," and sure enough, it was not good.
Well, it's like theater. What you're saying is, I mean, that old adage that if you basically make it seem like you're in a dramatic movie or in a television series, you're more likely to win over the jurors, because a lot of times when these jurors go into the courtroom, isn't it true that if they don't have any experience with the legal system, they expect things to unfold the way that they see them unfold on their favorite television shows? Yeah,
well, as prosecutors, we always have to tell people, and in fact, I make a specific reference to this. I did it in the case where the priest got killed, and they say this is not TV, okay? The crime was not solved in half an hour. There's not a special instrument that looks at a piece of dirt and says that's the guy who did it, okay? It's a flawed, we're flawed system, people. The system is very slow, it's very methodical. The crime scene processing is tedious, and here's the evidence that we have in the case. But you're trying to pull them away from the TV, letting life imitate art, if you will, scenario, because it happens all the time. But,
Yeah.
you know,
but as
listen,
we saw, like with the Casey Anthony trial, if you have a prosecutor that's not as exciting as the defense attorney, and the defense attorney brings that drama, even though that's not really the way it is in reality, a good defense attorney will bring the drama, or a good prosecutor will bring the drama. It's very effective.
You know,
I mean, look what Jose Baez did with no evidence to support his claim.
and with very little background, I believe, as a trial lawyer,
His
too.
first, right.
But you see, that's the point. You don't need to be a sophisticated law school grad. Like, I remember asking my dad, who's 86 years old and practicing law, on my first trial. Like, I was nervous, and, you know, I was a young assistant prosecutor, and I said, you know, am I going to be any good or whatever? He said, kid, you were going to be good from the time you were 5 years old. College, law school, the bar exam, that meant nothing. It's who you are as a person that translates as to whether you're a good trial lawyer or not. Like anything in life, education gets you to a place, but it doesn't mean you're going to be good. With my assistant prosecutors that I had, there were some who were just intuitively, innately unbelievable on their feet. They had common sense. They related good to a jury. They could anticipate issues. And there were some who
They dressed well, perhaps.
They dressed well. They just had that one in particular I could think of. It had that je ne sais quoi, I would say. And I would go watch as she would present her case, because I'm like, wow, she is just really like so good. The jury's just on the edge of their seats listening to her. Now, that doesn't mean that you need everyone like that. Not everyone is that intuitive and that skilled. We used to have a young assistant prosecutor who was like a choir boy. We used to call him the choir boy. He was kind of meek and hunched over, whatever, but he was deadly. He knew his case. He wasn't a yeller or a screamer. He wasn't a like overly emotional person, but the jurors just believed him because he looked like I said, like an altar boy. So
Yeah.
they believed what came out of his mouth.
Yeah,
So you don't have to
innocence.
be necessarily yelling and screaming. Be yourself, be prepared, have common sense. Those are the things that make a difference for a trial lawyer. I found as time is going on, sometimes you sit in the courtroom and there's a common sense thing that's coming out.
Yeah.
And the lawyer is so focused on asking questions in a series, but they're not flexible enough to realize that guy just gave you a confession on the stand, exploit it. Instead, they're going back to some inane thing over here. It's
Right,
very
because they're
hard.
married to their script.
They're married to
and
the
they're
script.
just so in the weeds.
Yeah, it's
that
hard.
people can't relate to it because, you know, they get bored with all the technicalities.
Trial work is very, very hard. It may look easy by people who know how to do it, but it is exhausting, and you've got to be listening and watching everything that goes on. And always, I used to have a split mind. You know, this is the OJ thing. You know the evidence you have in this part of your brain, but the jury doesn't. And so what's coming out in the courtroom has to go on this side of the brain, if you will. In other words, it's not what I know, it's what's been introduced. Right? And look at common sense on OJ. It's the one that your viewers will have a great knowledge of. The fact that they never introduced, think about this in general, the car ride with Al Cowlings with a gun, a ski mask, and $10,000 in cash. The prosecution never admitted that evidence because they were relying so much on the beaten up DNA evidence. I'm using this to illustrate the point of common sense. The DNA had been beaten up. The motives, Mark Furman and the issues with regard to him. What I would have done simply in my summation as a prosecutor after having introduced the car ride is say, ladies and gentlemen, I'd be very quiet and then I'd be very calm, which is unusual for me. So I'm changing my tempo now, right? From the jury's used to seeing me kind
It's
of
like a dance.
like I am right here.
Yeah.
I would just be very calm and I'd say, those $10,000 in cash, a ski mask, a gun, and running away from the police when your children have been orphaned is inconsistent with evidence of
Innocence.
not of innocence,
Yeah.
right? It is evidence of guilt, and that's all you need to know. Jurors will respond, in my opinion, more to that common sense argument. But why didn't the prosecutors introduce it? This is what can make a difference between whether somebody is found guilty or not guilty, the lawyering.
Yeah, and what you're saying is very interesting because you have to abide by all the technicalities. You have to know all of the verbose laws and what you can do and what you can't do and what you know versus what you're able to talk about.
Yep.
But at the same time, you have to entertain to an extent. So do you think that money comes into it? Because here we have a case with a millionaire, multimillionaire, who can afford an effective lawyer. He can afford one of these grandstanders that you're talking about. But yet he lost the friend, no offense to you, to include you in that category.
Hey, I wasn't there.
Yeah. But so the first trial he loses. Do you think he has a better shot at the second trial because he has a good attorney? And do you think a good attorney helped him get the conviction overturned?
Well,
is money a factor here?
Money doesn't buy you love, and it doesn't necessarily buy you a good lawyer.
It can,
But
though.
it can,
Right.
right? So, yes, people who have access to funds, I've seen many of them spend money on some pretty poor quality lawyering, but it does give you the ability to do something that people that don't have money can't do, which is find the really good kick-butt lawyer that's going to go in there and take no prisoners. And they're going to not only just, it's not about yelling and screaming, it's also about hundreds of hours of preparation, getting the right expert witnesses. Good lawyers are preparing for their trial the minute the client signs the retainer agreement. What I have seen is quite the opposite. They take the retainer and they go forward, kind of crossing their fingers that everything's going to be okay and hope that they're going to get a good plea agreement. In this case, will never go to trial. And then it becomes a disastrous scenario for the client because they're unprepared. When we take a case on, we have a whole team. We bring our investigative team in and the whole thing. We sit down, we go through a strategy just like we did as prosecutors. We have the whiteboard out. Here's where we want to go with the defense, and here's what we want to do. Here's the experts we're going to need. We're putting our case together so like in a week or two, we could try the case, even though it may take 2 years to get the trial.
Yeah, so the preparation is key.
But it costs money. I mean, look, with us, we tell people, listen, we're a boutique firm, right? We can't take on 50 cases and put that level of energy. That's what I was just going to say.
You can't stretch yourself too thin. What do you think about the fact that there was video surveillance of this Bob Ward guy in prison, and he had visits from his daughter and from some other family members and friends, and he was very nonchalant in these visits, and he seemed happy, and the lawyers are trying to use these videotapes of him enjoying guests when he's sitting in a cell all day long against him to say, oh, well, he doesn't care about the fact that he killed his wife.
Well, I haven't heard this piece yet, but are you saying the prosecutors are trying to introduce that?
Yeah.
Yeah, what I'm seeing here from some of the things that you've talked to me about.
Well, this was something that was contested in the beginning. But do you think that something like that should be introduced?
Absolutely not. And what concerns me...
But we hear jailhouse calls all the time.
Well, if you have an intercept that goes on in a jailhouse call, that there's admissions of guilt being made or tampering with witnesses, that's consciousness of guilt. That's a different story. But just to introduce irrelevant, all evidence under the evidence rules, right?
Yeah.
Rule number one has to be relevant.
Right.
It has to prove a material fact of the complaint. And it is not a material fact of a charge of murder that he's enjoying time with his family in a prison. And what concerns me about this is that is prosecutorial overreach. They, again, aren't getting it. You're introducing bad evidence, poisoning the evidence in the case, poisoning the jury. You're setting yourself up for another reversal if you get a conviction. That evidence is not relevant, and a good prosecutor wouldn't even attempt to introduce it.
So let me ask you this then. How do you, and this may be an obvious answer to you, but to people out there it may not be, how do you distinguish analyzing somebody's behavior or cadence on a 911 call versus their behavior or cadence when they're talking to family and friends during a visitation?
Right, so that's a great question, but it's about time and recency. The 911 call is occurring during the course of an event. The jail cell...
Is that part of the rules, that there's a set timeline?
Sure. I mean, it's a relevant piece of evidence because he's giving a statement about it. He's alerting the police, so it clearly is in play as far as relevance is concerned. What he's doing in the jail, other than trying to tamper with a witness or confessing, is not relevant. It's completely extraneous, and I'll use the phrase that the judge should be saying. Under Evidence Rule 404, which is what most states have, that the prejudicial value of that is outweighed, the value is outweighed by the prejudicial value of that evidence. In other words, it's so prejudicial and yet lends so little, if anything, to the case. I'm not including it. And I would imagine the judge probably would exclude that unless there's some way the prosecutor can make that relevant.
Yeah. And so now let's listen a little bit to the medical examiner, Jessica Schoenfeld's testimony, which we were discussing before, and we can expand upon that discussion when we come back.
What do you do for a living?
I'm currently a registered nurse.
Back in 2009, what were you doing for a living in September?
I was a medical legal investigator for the medical examiner's office.
And is the medical examiner's office a law enforcement agency?
No.
Can you tell us more about what it is?
It is a office that investigates the cause and manner of death for people who pass away in Orange and Osceola County.
And either in the late evening hours of September 21st of 2009 or the early morning hours of September 22nd, 2009, were you called out to a scene of a dead body out in Islesworth?
I was.
Do you recall about what time that happened?
I believe it was around between 3 and 4 in the morning.
And do you recall about when you arrived?
I can't say the exact time. I know that it was approximately a half hour after I received the initial notification.
Okay. And now, are there Florida statutes governing what the medical examiner's office is and what your jurisdiction is?
Yes.
Are you aware of those back in 2009 as an investigator for the medical examiner?
Yes.
And so when it comes to a crime scene or a suspicious death or anything within your purview, is there statutory rules about who the body belongs to, whose jurisdiction that is?
Yes.
And what is that rule?
The indication is that if the medical examiner has accepted jurisdiction to investigate a death, that the body, as you say, is then their jurisdiction, so nothing should be done to manipulate that body until someone representing the medical examiner is present on scene and has documented the body and obtained permission for anything to happen.
Now, do you make that call as the investigator, or does somebody else?
I will represent the medical examiner based on the delineated rules. So I would say, yes, what's okay and what's not okay based on the general understanding that the medical examiner has put upon the investigators. But if there's specific requests by law enforcement, I will then call the medical examiner and obtain certain permissions.
Well, I guess what I'm asking is, do you get that phone call at 3 or 4 in the morning from somebody in law enforcement, and then you make the decision whether the medical examiner's office accepts jurisdiction, or are you getting the phone call from somebody in the medical examiner's office saying jurisdiction's been accepted, get out of bed?
I make the determination.
Okay. And so based on, is it fair to say that you received some information about what people had observed at this scene?
Correct.
And based upon what was relayed to you, you made a decision that the medical examiner's office would accept jurisdiction.
Yes.
And then you got dressed and got out there.
No, I was currently dressed in the capacity of medical examiner. We are essentially on call during that time, so.
Okay. All right, so you get out there, and what do you do first?
The first thing I do is, before entering the scene, is I obtain permission from law enforcement as to where I can enter, what's okay for me to walk, where it is okay for me to walk, that kind of thing.
After being briefed on that, what did you do?
I started taking photographs.
All right. Permission to begin working with AU for identification with the witness?
Granted.
All right, do you have a screen up in front of you with a series of digital images in a directory?
I do.
All right, so we're looking at AU for identification. I'm going to look at first image number 1 in this directory. Are you familiar with this?
Yes.
And what is this?
It's a card that delineates the case number that's been assigned to this case, as well as the date that the picture is being taken and the name of the person as we understand it at that moment.
And was your understanding at that moment Wood instead of Ward?
Correct.
Okay. And I'm going to show you a few more images here. Image 8, opportunity to see that?
Yes.
Image 38.
Yes.
Image 51.
Yes.
Image 53.
Yes.
Image 62.
Yes.
Image 67.
Yes.
All right. So for those images that I showed you, and do the file names also reflect the medical examiner case number?
I can't see them, and I don't recall.
I took it away. That was very mean. Let me do it. There.
I believe so.
I can show you your first card again.
Thank you, if you want to. Yes.
All right, and were all those images that you had an opportunity to look at, is that fair and accurately depict what you saw as you went through the scene and documented it?
Correct.
And is it fair to say that some of those were taken just as documentation before any process began, but then some of that reflected the process of Mrs. Ward being bagged up.
Yes.
Now, who takes those photographs as she is being bagged up? Are you still taking those photographs, or is somebody assisting you?
No, I take all the photographs.
All right.
Welcome back to the Law and Crime Network. I'm your host, Amy Dash. We're seeing some activity in the courtroom, so we're going to toss over there. But Bob and I are going to continue to analyze this case. Oh, wasn't that a beautiful 3-box?
Yeah,
Do you like
nice.
our new studio, Bob?
Oh, it's beautiful.
It's really nice, right? A significant upgrade. So we're going to be continuing this case, which is Florida versus Bob Ward. This is his second bite at the apple. He was originally charged with the second-degree murder of his wife and convicted. It was overturned because his original defense attorney didn't object to some references that shouldn't have been brought up because he had a right to remain silent. And what happened is the prosecutor tried to use that against him, right?
Right.
The prosecutor tried to say, well, because he didn't comment on his wife in A, B, C, D, E, F, G instances, that means he didn't care.
Right.
And we saw that as a continuing theme, starting with the 911 call where he sounds completely stoic, and continuing all the way through his interrogation and then some other things. So actually, do we have audio there? Okay, let's go straight to the courtroom and listen to the judge. And welcome back to the Law and Crime Network. I'm your host, Amy Dash, here with former prosecutor Bob Bianchi as we're watching the trial of Florida versus Bob Ward, second trial after he was convicted in the killing of his wife, second-degree murder, and then it was overturned on a technicality that related to his right to remain silent. Bob, we were talking before about the motive here. The wife who was shot and killed, she was set to testify presumably against him in another case to talk about the financial difficulties that they were having and the fact that her husband was spending money despite being in bankruptcy because he was being charged, or he was being accused, I should say, by some of his former clients of fraud. And so she was going to testify against him. So obviously it wasn't all, rosy in their relationship. So there were problems there. Right? So does that constitute a motive? Is that enough?
Oh, sure. I mean,
it is.
Now, the judge will specifically instruct the jury that a prosecutor does not have to prove motive in order to win a case. But we love, love, love the motives. The motives give us the reason as to why the action took place, and it puts sharper focus on the conduct on that particular night. In this particular case, the cops were describing what was going on in the prosecutors in that household at that time in their lives as a powder keg, essentially something to that effect.
Boiler room.
A boiler room.
Yeah.
And
that it was like a pressure cooker. That was just, the tension was building.
Right. And she's testifying against the interests of him. There's broken glass, a wine bottle, a cigar burning on a chair when the crime scene people start showing up and the police start showing up. This is all bespeaking of, something going on, bad in the marriage. She's going to testify. There's your motive. And now something's happening of a violent nature prior to the actual shooting. These are all good facts for the prosecutor. So,
how are two people living together that have adverse interests like this, where the wife is going to testify against her husband?
Yeah, well, you know what happens.
And we didn't hear about something to the effect of a divorce in the works or anything like that.
Yeah,
so that makes it peculiar.
I don't know I don't know the value of what it was that she was going to testify and how against his interest that testimony was going to be. We'll hear as this case unfolds.
Yeah.
But motive evidence is something, let's use an interesting thing. We talked before about, well, what kind of evidence is relevant or not relevant? The interesting thing about motive evidence, it's under this Rule 404. It's my favorite rule. For all your viewers out there, if you got nothing better to do, Google Evidence Rule 404. It's called Other Act Evidence. And there are instances in which giving bad character evidence about a defendant is not admissible unless, Evidence Rule 404 says, it is to prove opportunity, motive, mistake, accident, or to rebut a claim or defense. Let me swipe all that garbage out and go to motive. In other words, the rule says you can't bring out in other words, that he had a bankruptcy, that he had financial problems. This typically would not be relevant evidence in a murder prosecution unless the prosecution says that's what the motive is. And under Evidence Rule 404, if the judge agrees, then the information gets introduced to the jury. And as a prosecutor, clearly, many times I've tried homicide cases, and there's one where I'm pretty strong on. Judge, I need to introduce the motive because otherwise the context of what occurred on that day will make no sense to the jury.
And certainly the timeline of her being set to testify just 3 days after she's killed makes it even more relevant.
Sure. I mean, and actually, that's one of the standards that the Supreme Court has said is the conduct that you're trying to admit as to motive recent in time. In other words, it can't be something that's so many years ago, 35 years ago when we first got married. I'm not even making this up. I actually heard that he didn't like something that I cooked, and he would make fun of me for cooking or whatever. This became the motive as to why all those years later.
And he harbored that resentment for 30 years until he exploded and killed the person.
That would be something where the court would say under the test, there's 4 prongs to the test, we won't go through them, but that would be so extraneous and so much time that went by. But when you're talking about testifying in 3 days against his financial, even if it's not against him, but it's against his financial interests, now you're starting the show. Isn't that a coincidence, the prosecutor would be saying? Yeah,
that he gets rid of his wife, is the prosecution's theory, before she's set to bring him down. Yeah, but you see, court. What I would be arguing as a defense lawyer on that, and this is what we do as the trial lawyers, right? No matter if I'm a prosecutor or a defense lawyer, I'm always arguing in my own brain the other side. But this is just too sloppy to be something that was planned. This to me speaks more of an argument happening maybe because of that, and then eventually something went wrong, and it could be an accident or it's something where they're struggling over a weapon and it misfires. That's where the defense wants. Sure. Okay, let's get back to the trial now, which is in session.